The word patent is referred from a Latin word called patrere, which means to lay open or to make available to public inspection. So an patent is an exclusive right granted to for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. So patents are being governed by the Patents Act of 1970, which is legislation that still governs patents in India, and it first came into force in 1972. So the main motto to enact a patent is to encourage inventors to contribute more in their field by awarding them the exclusive rights for their inventions. Okay. And it is in modern times, it's mostly regarded as the right granted to an inventor. It's a right. It's a right granted to the inventor for the invention of anything new, useful, non-obvious, a machine or an article of manufacture. Okay, so there are three basic tests for a patent. Firstly, the creation must be novel, which means it should be new. It should not already exist. Secondly, the creation must be non-obvious. It should be a considerable advance over a prior one, and a slight modification in technique will not issue the product the right to a patent. It has to be something that is bringing out new changes in the field. It shouldn't be something like you cannot change one thing in it and expect it to be called a new and shiny thing. It has to be non-obvious. It should have an advancement. And thirdly, the innovation must be beneficial in a legitimate manner, which means it should not be exclusively employed in any unlawful work and must be valuable to the world in a honest way. Which means the invention cannot be used for unlawful things. It has to be used in a bona fide manner. In a bona fide manner. And so there are certain loopholes that some people can exploit in this, but an invention is considered new on the date of filing an application if any such invention is not currently known to us. Okay, in any form the public must not know about it, in oral, in writing, or anything. And if the manufacture or the product is already known to the public domain, it is not considered a new invention and the patent filing cannot be done. Another thing to be noted is that patent filing is territorial. Thus, it can only be applied in the country where it has been invented or has been granted. So if I have a product that I have filed for a patent in India, it is only protected in India. I cannot go to another country, I cannot go to the USA and say this is my patent, you cannot use this. A patent is strictly territorial. It is a territorial right. Some general pointers for patent filing are that a patent protection is granted for a limited period, generally for 20 years from the filing date of the application. And you can renew this every now and then, but generally the first rule is that it's filed for 20 years. Patents are territorial rights. Again, I've explained this before. The territorial rights, it's only applicable in the country or region in which the patent has been filed in accordance with the law of the country or the region. Okay, and then the patent owner has the right to decide on who may and who may not use the patented invention for the period in which the invention is protected. In other words, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others. So only the patent owner has the right to dictate on how his patent is being used, or it can result in a lawsuit.